Today, I will talk about the 10th Amendment to the United States Constitution. It reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." When I use brown text, it's a direct quote. So this is saying that the Constitution delegates certain powers to the federal government, the United States, and it prohibits certain things prohibits the states from doing certain things, such as raising their own armies. And any other rights are reserved for the states or the people. So along with the Ninth Amendment, this was intended to emphasize the limited power of the federal government. The Constitution explicitly gives certain powers to the federal government and prohibits the states from doing certain things. All other powers not covered by the above point are reserved for the states or the people. So what powers are included in this? In the Articles of Confederation, each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled. So in the Articles of Confederation, it has the term expressly delegated, and the word expressly was not used in the 10th Amendment. So in certain court cases, the Supreme Court has said, well, because it doesn't say expressly in the 10th Amendment, if it did say expressly, you have to have it particularly written out directly. But because it doesn't, we can make some assumptions about what it means. So that's a point of contention. James Madison said the powers delegated by the proposed Constitution to the federal government are few and defined. Those which remain in the state governments are numerous and indefinite. In the summer of 1787, the Constitutional Convention in Philadelphia was going on, and they were debating the Constitution and what it should say. And late in the process, someone proposed a Bill of Rights. However, they decided not to include a Bill of Rights in the Constitution as they completed it in September 1787. So the Federalists, who were arguing for the adoption of the Constitution, argued that if any rights were in a protected list in the Constitution, that it might be presumed that other rights not listed were not protected. They argued that any list would be incomplete, and it was better to limit the government's power to only a short list of enumerated powers. However, a few rights were mentioned in the text of the Constitution, such as the rights of trial by jury in Article 3, Section 2, and habeas corpus in Article 1, Section 9. So the Anti-Federalists, who were arguing against ratification of the Constitution, said, well, your argument already has some holes in it because you've already listed a few rights in the Constitution, and also that if people expansively interpret the Constitution, that could greatly expand federal power. So that's a threat to our rights if people are expansively interpreting it. So as the states were ratifying conventions were arguing whether to accept the Constitution or not, they ended up approving it, but many on the understanding that additional rights would be protected by amendments added later, because in Article 5 you have a right to amend the Constitution. So they said, well, we'll go ahead and approve it, but you need to add a Bill of Rights. So that's how we ended up with our Bill of Rights, the first 10 amendments to the Constitution, that these states accepted the Constitution as written, but said, yes, it's really important that we list and specifically protect a number of rights that we feel are particularly important. So hence the Bill of Rights. So the 10th Amendment restates the principle of federalism. It's saying that there's a mixed sovereignty between the federal government with limited enumerated powers. Enumerated powers are numbered, listed specifically. So power 1, the power to tax. Power 2, the power to coin money. Power 3, etc. So certain numbered rights are given to the federal government, and the state governments have general legislative powers. So they can pass not exactly everything they want, but many different laws they can pass at the state level. But the federal government is limited. Founders wanted to emphasize that there are no other powers of the federal government other than what's specifically stated. So James Madison goes on in the quote we saw earlier. The powers delegated by the proposed Constitution to the federal government are few and defined. those which remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects as war, peace, negotiation, and foreign commerce. The powers reserved to the states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. So Madison is arguing that the federal government will be focused on interaction with other countries, war, peace, negotiation, foreign commerce, that the federal government presents a united front for all the United States in dealing with other countries. But everything that affects people's ordinary lives, everyday lives, their lives, liberty, property, those are all affairs of the several states. Each individual state has the right to regulate and pass laws relating to that. So in people's normal lives, they should really only be interacting with their state government, not with the federal government. And the federal government really shouldn't have anything to say to individual people on how they run their lives. And also internal order, improvement, and prosperity is up to the states, not the federal government. So now we'll look at some court cases that have touched on the 10th Amendment. Starting with McCullough versus Maryland in 1819, Chief Justice John Marshall adopted a broad interpretation of the Necessary and Proper Clause, allowing Congress to establish a national bank, because the reasoning they stated was that if the end was allowed in the Constitution, then any appropriate means is allowed. So this sounds pretty much like the ends justify the means, which tends to get you into quite a bit of trouble if you follow that. But at any rate, they were reading broadly for the Necessary and Proper Clause and said that, well, if the end is okay, whatever means you think appropriate is okay. In the legal, so this started to expand the way you might interpret federal powers. The legal tender cases in 1871 were about the power to issue paper money, because in Article 1, Congress is given the power to coin money. It doesn't say print paper money, just coin money. So the Supreme Court, in deciding this case, declined to locate this power in any enumerated power, saying that there are other powers beyond the enumerated powers and things that follow directly from them. So this seems to be precisely the reasoning that the 10th Amendment was put in place to prevent. If they had pointed to the phrase Congress has the power to coin money and said that printing paper money is similar to coining and that is the reason it has the power, that at least would be pointing to an enumerated power. However, they didn't. They just said there are other powers beyond the enumerated ones. So this seems to be ignoring the content of the 10th Amendment. However, in Hammer versus Dagenhart in 1918, the Supreme Court held that Congress could not intrude on an area of state police power, in this case regulating the interstate transport of things produced with child labor, and also other cases that limited the power of Congress to tax various things. So in this case, and the others following it, they said that there are some limits by the 10th Amendment which are limited to the state acting, not the federal government. So there's some sphere of influence where it's up to the states if they want to police it or pass laws regarding those. Likewise, in ALA Schechter Poultry Corp. versus U.S. in 1935, the court held that the Interstate Commerce Clause did not apply to intrastate poultry sales, and that an economic emergency did not justify the law. So the Interstate Commerce Clause, Congress is allowed to regulate interstate commerce between states. But this law was applying to poultry sales inside of a state, intrastate. So the court said, no, it's not going, this commerce isn't going between states, so it's not Congress's domain to regulate it. It can be regulated by the states, but not by the federal government. And also interestingly, they said that an economic emergency, this was the middle of the Great Depression, did not justify the law. So there's no emergency out in the Constitution. If it's an emergency, you can ignore what it says and do what you want. No, the court said that's not the case. You have to follow the Constitution regardless of what circumstance you might be in. In the U.S. versus Darby in 1941, we were in the middle of Franklin Roosevelt's New Deal in the 1930s, and that entailed a huge expansion of government. The Supreme Court held that the 10th Amendment is only a truism that doesn't limit federal power, and this allowed for growth far beyond the enumerated powers. During the 1930s, Franklin Roosevelt wanted to pack the court to expand the number of members of the court from 9 to, I believe, 15, because he was upset that they were giving unfavorable rulings, maybe like the poultry case above, that was limiting federal government power. So he was threatening to say, well, I'll add more members to the court so you make decisions that favor my administration. So possibly under that sort of pressure, the Supreme Court said, well, the 10th Amendment doesn't really limit federal power. A few years later, in another case, they directly said, the 10th Amendment does not operate as a limitation upon the powers express or implied delegated to the national government. So they seem to have completely thrown out the 10th Amendment and said, well, it doesn't really mean anything. It's no sort of limitation on federal government. So if that's truly the case, I don't know why the founders would have bothered to put in the 10th Amendment if they were going to just throw it out like that. It went as far in Wickard versus Filburn in 1942, with the court saying that Congress has the power to regulate the production of wheat for consumption on a farmer's own farm under the Commerce Clause. This isn't just even commerce within a state, it's the farmer growing food for his own family. And they said, yeah, Congress can regulate this under the Commerce Clause. There was also a similar finding in Gonzalez versus Raich in 2005 on the home production of marijuana, saying that due to the Commerce Clause, Congress could regulate that. However, in the National League of Cities versus Usury case in 1976, the pendulum seemed to swing back the other way, citing the 10th Amendment to prevent the Fair Labor Standards Act from applying to state employees. The federal government is barred from transgressing on functions essential to a state's separate and independent existence. So this put a limit on what the federal government could do about how a state employs its workers. So saying a state employing its own workers is not a function of the federal government to regulate. The state can hire and have conditions of employment as it sees fit, and the federal government can't really interfere in that realm. However, in 1985, this was overruled in Garcia versus San Antonio Metropolitan Transit Authority. So again, the Fair Labor Standards Act, they said, well, that applies. Congress can regulate state and local governments hiring workers. So the court flip-flops back and forth on this. In New York versus the United States in 1992, the court ruled that Congress cannot force a state legislature to dispose of low-level radioactive waste or be responsible for it. They can't commandeer the states to enforce federal regulations. So if the federal government has certain regulations, they need to enforce them themselves. They can't say to the states, oh, you have to enforce our federal regulations. And also in Gregory versus Ashcroft in 1981, the court held that the federal government cannot regulate the employment of state judges because that's impinging on the state and their own courts and how they run their business. In U.S. versus Lopez in 1995, the court struck down a law prohibiting possessing a gun at or near a school because this does not fall under the Commerce Clause. So their reasoning was that if you possess a gun near a school, this is not involving commerce, and there's no power of the federal government to regulate this under the Commerce Clause. So the law was struck down. Presumably the state, under their general legislative power, could make such a law, but the federal government cannot. Also, in United Haulers Association versus Oneida Herkimer Solid Waste Management Authority in 2007, a state could favor its own waste treatment facility over out-of-state competitors, but cannot favor local private facilities, because this is a traditional government activity dealing with waste. So the state has some freedom to run its own affairs there. And on the matter of voting rights in Shelby County versus Holder in 2013, the Supreme Court struck down Section 4 of the Voting Rights Act of 1965, which required certain states to get pre-clearance from the Department of Justice before changing voting procedures or districting. So Justice Roberts wrote that the federal government must not discriminate against the equal sovereignty of the states absent current evidence of discrimination. So back in 1965, when the Voting Rights Act was passed, some states were definitely discriminating against the rights of African Americans and denying them rights to vote, which is why the act was passed in the first place. But Justice Roberts said in 2013, there's no current evidence of discrimination, so the states have to be treated equally. You can't say, well, certain states have to get pre-clearance from the Department of Justice on their voting procedures when other states don't need to do that. So it put the states on an equal footing, equal sovereignty. The last case is the National Federation of Independent Business versus Sebelius in 2012. Congress cannot mandate individuals to buy health insurance. Obamacare was the law, but it did uphold it as a tax. So it says Congress can regulate commerce, but it cannot force commerce. So it can't force you to buy something, but if you're choosing to buy something on your own, it can regulate the conditions. So the police power to regulate individuals as such, as opposed to their activities, remains vested in the states. So regulating individuals would be like, say, a state having a law against murder. That's regulating individuals. But under the Commerce Clause, they allow the Congress to regulate people's activities. But regulating individuals as such remains the state's domain. So in conclusion, the 10th Amendment is meant to enforce the structure of federalism where some powers belong to the federal government and many others belong to the states and the people. So while the 9th Amendment deals with rights, the 10th Amendment deals with government power. The Supreme Court has been very inconsistent in applying the 10th Amendment, often ignoring it and occasionally applying it in limited cases. But it seems that they rarely apply it in its full strength as written, that no enumerated power, or no power besides the enumerated powers, belongs to the federal government, which would greatly limit the power of the federal government. So it's meant to limit the power of the federal government, which has increased immensely in the past century, but government's not very interested in an amendment that limits its power. The 9th and 10th Amendments are probably the most ignored amendments to the Constitution, and enforcing them vigorously would be a way to dramatically rein in the overreaching power of the federal government.
Because the flag still stands for freedom, and they can't take that